Contradictory chain of title claims. No power on earth has a right to take our property from us without our consent. The law cannot be bent by favor, not broken by power, nor corrupted by money. For not only if it be overthrown, but even if it be neglected or carelessly preserved, there is nothing secure in what anyone may think he has, or will inherit from his father, or yet may leave to his children. I believe that banking institutions are more dangerous to our liberties than standing armies. Furthermore, tampering with the administration of justice in the manner indisputably shown here involves far more than an injury to a single litigant. It is a wrong against the institutions set up to protect and safeguard the public, institutions in which fraud cannot complacently be tolerated consistently with the good order of society. Surely it cannot be that preservation of the integrity of the judicial process must always wait upon the diligence of litigants. The public welfare demands that the agencies of public justice be not so impotent that they must always be mute and helpless victims of deception and fraud. Contradictory claims regarding an ownership transfer in 2002. Claim 1. Coldwell Banker Mortgages signed the note to Fannie Mae. PHH Mortgage Services stated that it held the original note through its subsidiary, Coldwell Banker. PHH believes that note was transferred to the Federal Home Mortgage Association, Fannie Mae. The district court found the note was assigned from Coldwell Banker Mortgage to Fannie Mae in December of 2002. We submitted a letter from Fannie Mae dated May 2, 2013 in our defense of PHH Mortgage Services summary judgment motion. This letter provided proof the chain of title was incomplete, fraudulent, and that PHH Mortgage Services did not have standing to foreclose. Other than this letter, no assignment in the record or other evidence presented at that time demonstrated Fannie Mae had ownership interest in our property in 2002. Judge Michael Griffin ruled this letter was irrelevant and admissible hearsay and struck it from the record. We filed a motion for reconsideration to reverse this decision, but Judge Michael Griffin refused to consider it due to timeliness alone. The Idaho Supreme Court refused to address this issue on appeal by only considering whether Judge Michael Griffin was wrong to refuse to reconsider his decision, instead of whether he was wrong to make his decision. I.e., this letter, which could have ended this litigation long ago, prohibited the foreclosure sale, and rendered any ejectment action moot, was never considered. However, both courts, based solely on this evidence, prejudicially proceeded to determine Fannie Mae was assigned the note in 2002. Refusing to consider evidence that required PHH Mortgage Services' case to be dismissed, then referencing the same information to attempt to cure a defect in the chain of title narrative, exhibited extreme prejudice and judicial bias, and has substantially damaged and injured our rights and ability to secure relief. PHH Mortgage Services and Coldwell Banker Mortgage were separate and distinct entities in 2002. Coldwell Banker Mortgage was not a subsidiary, DBA, nor owned by PHH Mortgage Services in part or in whole. As such, PHH Mortgage Services did not and could not acquire any ownership interest from Coldwell Banker Mortgage as the originating lender. Further, Coldwell Banker Mortgage allegedly assigned all rights in our property to Fannie Mae on December 27, 2002. No further rights or interest to our property could or were available to be assigned to PHH Mortgage Services by any subsequent alleged merger or purchase with or of Coldwell Banker Mortgage. The documented truth surrounding any current or existing relationship between Coldwell Banker Mortgage and PHH Mortgage Services in 2002 irrefutably demonstrates any of PHH Mortgage Services' subsequent claims of ownership interest from Coldwell Banker Mortgage are fraud. Claim 2. Coldwell Banker Mortgage assigned the note to Freddie Mac. J.P. Morgan Chase Bank stated, the note was immediately sold to Freddie Mac, but PHH remained as the servicer of the loan. J.P. Morgan Chase Bank stated, in February 2010, PHH repurchased the note from Freddie Mac and began servicing the note. No other evidence in the court or county records demonstrates Freddie Mac's involvement in the alleged note. J.P. Morgan Chase Bank removes itself from the chain of title with this narrative of assignment transfer. This prevents J.P. Morgan Chase from future claims of ownership transfer to PHH Mortgage Services. Contradictory claims regarding an ownership transfer in 2007. Assignment from Coldwell Banker Mortgage to J.P. Morgan Chase Bank recorded as instrument number 207590. One cannot grant what one does not have. This 2007 assignment is impossible, void, and evidence of fraud. Factual evidence and the rulings of the court affirm Coldwell Banker Mortgage assigned the loan to Fannie Mae in December 2002. Coldwell Banker Mortgage cannot subsequently assign the loan again to someone else 5 years later. Further, the missing legal description, execution by a known robo-signer, and false notarization support fraud. Claim 1. J.P. Morgan Chase Bank denied being a party to this 2007 assignment in their pleadings. J.P. Morgan admits that the Nickersons' note and mortgage were signed by Coldwell, but lacks sufficient information to form a belief as to the parties and dates of assignments, and therefore denies the remaining allegations. Claim 2. District Court Judge Michael Griffin then claimed J.P. Morgan Chase Bank obtained ownership in 2007. J.P. Morgan Chase Bank, Chase, owned the note and serviced the loan from the end of 2007 until the beginning of 2010. J.P. Morgan Chase acquired the note in November of 2007. Claim 3. J.P. Morgan Chase Bank again denied receiving any ownership from this 2007 assignment in their answers to interrogatories. J.P. Morgan further objects to this interrogatory as it mischaracterizes the facts, contending that J.P. Morgan purchased the Nickersons' note, whereas J.P. Morgan was a servicer of the note and not a purchaser. J.P. Morgan objects to this interrogatory because it mischaracterizes the facts, contending J.P. Morgan purchased the note, whereas J.P. Morgan was a servicer of the note and not a purchaser. J.P. Morgan did not purchase the note, but was merely a servicer of the note. Claim 4. J.P. Morgan Chase Bank then claimed ownership in a Notice of New Creditor letter on December 3, 2009, not November 20, 2007. The identity, name, address, and telephone number of the new creditor is J.P. Morgan Chase Bank, N.A. The date of the sale of your mortgage loan to the new creditor was December 3, 2009. Claim 5. Fannie Mae claimed ownership from 2002 to 2009. Our records show that the loan was sold to Fannie Mae on December 27, 2002, and Fannie Mae's interest in the loan terminated as of December 3, 2009. Fannie Mae's claim of ownership from 2002 to 2009 and J.P. Morgan Chase Bank's Notice of New Creditor in December 2009 are factual challenges to any ownership transfer occurring in this 2007 assignment. This assignment creates a broken chain of title. This is fully explained after Section 3, Claim 6. This 2007 assignment was executed November 20, 2007 and recorded December 20, 2007. J.P. Morgan Chase Bank assumed servicing of our loan in November 2007. J.P. Morgan Chase Bank's immediate initiation of abusive debt collection practices and aggressive demands for us to sign over our property to them to avert further negative consequences to our credit and financial portfolio suggests this 2007 assignment was originally intended to allow J.P. Morgan Chase Bank to wrongfully foreclose. When their threats and intimidation failed to move us, and our hawk-eye oversight prevented them from creating a default with our account, servicing was transferred to PHH Mortgage Services. PHH Mortgage Services then maliciously inserted our account into a large batch of homes, i.e. hundreds, assigned to Just Law to foreclose on. Just Law then fabricated the 2010 assignment to pursue a non-judicial foreclosure. When this attempt was stopped, this judicial foreclosure was initiated and the banksters were left to navigate their false claims and assignments. The banksters' only recourse was to coerce or con the courts into granting summary judgments, so this case could be quickly disposed of and their criminal actions judicially concealed. We fought back against acute regulatory failure, procedural manipulation, legal chicanery, attorney negligence, official overreach, and judicial tyranny. We refused to bend or bow to this attack on our homeland. Now justice finds itself in a very precarious place, and we are fighting in faith and prayer, trusting the truth will set us free. Contradictory claims regarding an ownership transfer in 2010. Assignment from J.P. Morgan Chase Bank to PHH Mortgage Services recorded as instrument number 214459. Claim 1. J.P. Morgan Chase Bank claimed they never had ownership to secure summary judgment, and therefore denied this 2010 assignment occurred in 2012. J.P. Morgan, as servicer of the loan, did not sell the Nickersons' note. J.P. Morgan did not purchase, own, or sell the Nickersons' note and merely acted as a servicer of the loan. J.P. Morgan further objects to this interrogatory as it mischaracterizes the facts, contending that J.P. Morgan was the owner of the note and in position to determine to foreclose or not to foreclose, when in fact J.P. Morgan was a servicer of the note. As a servicer for the Nickersons' loan, J.P. Morgan is not aware of the information exchanged in the transfer/sale of the note between buyer and seller, when in fact J.P. Morgan was merely a servicer of the note. J.P. Morgan Chase Bank also stated PHH Mortgage Services, not J.P. Morgan Chase Bank, purchased the note from Freddie Mac in 2010. In February 2010, PHH repurchased the note from Freddie Mac and began servicing the note. Claim 2. PHH Mortgage Services also denied this 2010 assignment took place and claimed Fannie Mae, not J.P. Morgan Chase Bank, assigned the loan to them. PHH Mortgage Services stated, Fannie Mae assigned the note back to PHH. There was no agreement between PHH and Chase. The assignment of the note was directed by Fannie Mae. PHH Mortgage Services has never owned or had ownership in our property, so it was impossible for Fannie Mae to assign anything back to PHH Mortgage Services. The use of the term back is intended to confuse, mislead, and misrepresent the truths of this matter, to defraud us of our property rights and commit fraud on the court and the world at large. Factually, there is no going back available for PHH Mortgage Services. Additionally, there has never been any assignment or evidence submitted to the court or any transaction recorded in the county records to support PHH Mortgage Services' claim of ownership from Fannie Mae. Further, this 2010 assignment from J.P. Morgan Chase Bank to PHH Mortgage Services was executed by a known robo-signer for 5 different companies. Claim 3. PHH Mortgage Services then contradicted previous claims by claiming the 2010 assignment did take place to secure summary judgment in 2014. By June 2010, PHH had obtained assignment of the Nickersons' deed of trust and promissory note. An illegal contract cannot be enforced. We did not sign a deed of trust with Coldwell Banker Mortgage. Rather, we refused to place a deed of trust against our warranty deed at closing as we had a competent understanding of the differences between a mortgage and a deed of trust. Coldwell Banker Mortgage and the closing agent altered closing documents to reflect we were signing a mortgage, not a deed of trust. They assured us we were in fact signing a mortgage and that all our judicial rights were preserved. Both informed us the deed of trust cannot be legally placed on an over 40-acre Idaho property and that our property was an over 40-acre agricultural property. However, without our knowledge or consent, Coldwell Banker Mortgage and Clearwater Land Title Company fraudulently then filed an illegal document in the county land records that does not reflect the agreements made and is not a valid document on its face. Number 1. It is incomplete and does not reflect the agreements executed. 2. It appoints a trustee and a mortgage does not have a trustee. 3. It contains a power of sale clause and a mortgage has no power of sale clause. 4. It does not include the revocation of the power of sale clause addendum. 5. Other such defects exist. Since this property was subsequently sold to Fannie Mae with false claims of being only a 30-acre parcel, this altering of the records and false filings, presumably done to meet Fannie Mae guidelines, created illegalities the banks needed to conceal. District Court Judge Michael Griffin refused to acknowledge the fraudulent nature, prejudice, and injuries caused by this issue. He also allowed PHH Mortgage Services and J.P. Morgan Chase Bank to encumber the entire property in violation of the original agreement. Claim 4. District Court Judge Michael Griffin determined J.P. Morgan Chase Bank never owned the loan in his 2012 summary judgment. The District Court said there was no contract between Chase and the Nickersons that has been presented to the court, nor did the court in its examination of the record find any such evidence. The 2010 assignment from J.P. Morgan Chase Bank to PHH Mortgage Services was in the record at the time Judge Michael Griffin granted this 2012 summary judgment. However, Judge Michael Griffin determined that J.P. Morgan Chase Bank had no ownership in the property, which barred PHH Mortgage Services from later claiming any beneficial interest was transferred to them by J.P. Morgan Chase Bank through the 2010 assignment. By law and fact, any acknowledgement of the 2010 assignment being valid requires this determination, the 2012 summary judgment, and all subsequent judgments to be reversed. Claim 5. District Court Judge Michael Griffin then contradicted his 2012 summary judgment findings in 2014 by stating J.P. Morgan Chase Bank assigned ownership to PHH Mortgage Services in the 2010 assignment. This new finding prejudicially established PHH Mortgage Services had standing to foreclose and allowed Judge Michael Griffin to grant the 2014 summary judgment. The district court stated, Chase assigned the note to PHH in 2010, June. This contradiction in judgment demonstrates extreme prejudice and judicial bias against us and corroborates this foreclosure has not been fully or fairly litigated. Foreclosure and ejectment actions necessarily require ownership to be proven. The court's own contradiction of facts created genuine issues of fact. No additional evidence was added to the record to demonstrate J.P. Morgan Chase Bank had beneficial interest in 2010 to assign to PHH Mortgage Services prior to this change in opinion. This judgment completely reverses the factuality of the 2012 summary judgment and demonstrates all rulings associated with it and prejudices caused by it are unjust and unfair. Claim 6. The Idaho Supreme Court's 2016 ruling demonstrated an incomplete chain of title, but the Idaho Supreme Court ignored the defects and did not act to stop this wrongful foreclosure. The district court determined that the original loan to the Nickersons was made by Coldwell Banker Mortgage and was originally serviced by Mortgage Service Center. In December of 2002, the note was assigned to Fannie Mae, and J.P. Morgan Chase acquired the note in November of 2007, at which point Chase Home Financial began servicing the loan. In February of 2010, Mortgage Service Center resumed responsibility for loan servicing, and in June of 2010, Chase assigned the note to PHH. The Supreme Court ruled J.P. Morgan Chase Bank acquired the note in November 2007, but failed to determine who J.P. Morgan Chase Bank acquired it from. This ruling rendered the chain of title incomplete and entangled the law of the case as an accessory to fraud and forgery. The only evidence J.P. Morgan Chase Bank acquired the note in November of 2007 is in the 2007 assignment recorded as instrument number 207590. This assignment claims Coldwell Banker Mortgage, not Fannie Mae, assigned the loan to J.P. Morgan Chase Bank in 2007. As shown above under Section 2 and determined in the Supreme Court's ruling, Coldwell Banker Mortgage had no rights to assign to J.P. Morgan Chase Bank in 2007 because their rights had already been assigned to Fannie Mae in December 2002. Thus, this 2007 assignment did not and could not occur, and the filing of it constitutes a felony offense. Further, Fannie Mae has stated it owned the loan from December 2002 to December 2009. J.P. Morgan Chase Bank claimed in a notice of new creditor letter they acquired it in December 2009. Therefore, J.P. Morgan Chase Bank did not and could not acquire it in 2007, and the Idaho Supreme Court erred in their ruling. All truth, facts, and evidence within and outside of the record demonstrate any claims of ownership by PHH Mortgage Services are incomplete, inconsistent, illegal, and conflict with the truth and factual reality of the real and true occurrences surrounding the ownership of our property. We are the true and rightful owners of our property by law and by fact. No power on earth has a right to take our property from us without our consent. Claims regarding an ownership transfer in 2017. Assignment from J.P. Morgan Chase Bank to PHH Mortgage Services recorded as instrument number 230960. Claim 1. J.P. Morgan Chase Bank claims they are the holder of our note and mortgage in 2017, 3 years after PHH secured a summary judgment stating PHH was a holder of our note and mortgage in 2010, in an assignment recorded as instrument number 230960. This 2017 assignment, coupled with J.P. Morgan Chase Bank's QWR response of May 21, 2018, in which J.P. Morgan Chase Bank claims they were the current owner of our loan, documents J.P. Morgan Chase Bank's affirmation that the 2010 assignment from J.P. Morgan Chase Bank to PHH was void and never occurred. Claim 2. Per PHH Mortgage Services admissions, the 2010 assignment PHH Mortgage Services relied upon for standing to foreclose in 2014 was void and invalid. PHH Mortgage Services admitted when questioned about this 2017 assignment, the reference document speaks for itself and merely clarifies the land records to conform to what had already been decided through the underlying litigation. In answering our allegation that this 2017 assignment makes PHH Mortgage Services' ownership claim and foundation for standing in 2010 fraudulent, PHH Mortgage Services replied in paragraph 12 of their answer, with respect to the allegations in paragraph 40, PHH admits only that the referenced assignment is a matter of public record and speaks for itself. J.P. Morgan Chase Bank's affirmation through the 2017 assignment that the 2010 assignment is void and PHH Mortgage Services admissions above represent convincingly clear admissions of fraud, fraud on the court, fraudulent concealment, as well as concession of forgery. PHH's admissions demonstrate PHH Mortgage Services knew the 2010 assignment was void and invalid, and the county records were not authentic. Not only is conforming the records to support false claims illegal, but a foreclosure action and verdict should conform to the truths in the county record, not the other way around. Two illegal acts cannot and do not make a legal act. Accepting the preposterous position that it is okay for a non-owner, i.e. bankster, to foreclose and then fix the land records to legalize the foreclosure violates Idaho and United States constitutionally granted property rights, blatantly disregards Western civilization's centuries-old methods of recording property transfers, negates long-standing statute and case law, and defies common sense. Such a determination results in the untenable position that no property in the state of Idaho is secure. Claims of ownership in response to federally required information requests. Claim 1. Fannie Mae claimed ownership from 2002 to 2009. Our records show that the loan was sold to Fannie Mae on December 27, 2002, and Fannie Mae's interest in the loan terminated as of December 3, 2009. Claim 2. J.P. Morgan Chase Bank claimed ownership on December 3, 2009 in a Notice of New Creditor letter. The identity, name, address, and telephone number of the new creditor is J.P. Morgan Chase Bank, N.A. The date of the sale of your mortgage loan to the new creditor was December 3, 2009. Claim 3. J.P. Morgan Chase Bank still claimed ownership in January 2014 during the foreclosure action. We sent a QWR in accordance with RESPA 12 U.S.C. 2605E in December 2013. J.P. Morgan Chase Bank responded in a letter dated January 10, 2014. However, this letter was mistakenly mailed to a different address than requested, so it was not properly or timely received. J.P. Morgan Chase Bank claimed ownership in their response. The investor for this loan is J.P. Morgan Chase Bank, National Association. Claim 4. J.P. Morgan Chase Bank continued to claim ownership in May 2018, after the sheriff's sale had occurred. We sent a QWR in accordance with RESPA 12 U.S.C. 2605E in May 2018. J.P. Morgan Chase Bank responded in a letter dated May 21, 2018. J.P. Morgan Chase Bank claimed ownership in their response. The investor for this loan is J.P. Morgan Chase Bank, N.A. The ownership of your loan may change from time to time during the loan term, but this is the current owner. Claim 5. PHH Mortgage Services never claimed ownership prior to the sheriff's sale, independent of court proceedings. We sent PHH Mortgage Services a QWR in accordance with RESPA 12 U.S.C. 2605E in December 2013. PHH Mortgage Services responded in a letter dated December 24, 2013. In their response, PHH Mortgage Services failed to assert ownership and stated they were providing an assignment. The assignment provided was the void 2007 assignment from Coldwell Banker to J.P. Morgan Chase. Obviously, that assignment did not and could not provide ownership to PHH Mortgage Services. Notably missing was the forged 2010 assignment from J.P. Morgan Chase to PHH Mortgage Services. PHH Mortgage Services did not inform us who the owner of the loan was or claim ownership in answer to our direct questions. This was 3 years after they supposedly gained ownership and began foreclosure proceedings. Contradictory claims of ownership post-foreclosure sale. Claim 1. J.P. Morgan Chase Bank has claimed ownership by a foreclosure auction in National Real Estate Listings and in response to a QWR. National Real Estate Listings lists J.P. Morgan Chase Bank as the lender and owner of our property by foreclosure auction. The property for sale status changed from for sale to no longer for sale or rent after we exposed the listings to the court. An interesting element of the listings is J.P. Morgan Chase Bank only shows 30 of the 50 acres for sale. The for sale price for 30 acres is listed as $633,200. This again demonstrates the accepted credit bid of $333,000 for all 50 acres was a grotesquely inadequate price. As stated in Point 5 Claim 4, We sent a QWR in accordance with RESPA 12 U.S.C. 2605E to J.P. Morgan Chase Bank on May 15, 2018. This request for information was sent post the foreclosure sale. J.P. Morgan Chase Bank responded in a letter dated May 21, 2018. In their response, J.P. Morgan Chase Bank claimed to still be the owner. The investor for this loan is J.P. Morgan Chase Bank, N.A. The ownership of your loan may change from time to time during the loan term, but this is the current owner. Claim 2. PHH Mortgage Services claimed ownership and right to possession in 2018 for the first time after the sheriff's sale. The first time, independent of court proceeding, PHH Mortgage Services ever claimed to be the owner of our loan was after the sheriff's sale. On May 11, 2018, and again on May 22, 2018, PHH Mortgage Services claimed ownership. The owner of your loan is as follows: PHH Mortgage Corp. The owner of the loan is PHH Mortgage Corporation. As shown above in Claim 1 of this section, J.P. Morgan Chase, not PHH Mortgage Services, claimed to own the loan on May 21, 2018. Further, PHH Mortgage Services contradicted their own claim to own the loan in response to a request for admission. Request for admission number 20. Admit, on May 21, 2018, J.P. Morgan Chase Bank, N.A. alleged they are the holder of our note and mortgage. Response to request for admission number 20. Plaintiff objects. Plaintiff further denies the request because as of May 21, 2018, where a sheriff's sale had already taken place, there was no longer a note or mortgage to hold. If there was no longer a note or mortgage to hold on May 21, 2018, how could PHH Mortgage claim to own the loan on May 22, 2018? They could not. Another significant issue of fact in dispute is that in response to a federal information request, PHH Mortgage Services claimed PHH Mortgage Corp., not PHH Mortgage Services, was the owner of the property in May 2018. This differentiation between the two entities creates new issues and questions of fact as to whether PHH Mortgage Services has fraudulently claimed ownership based on the sheriff's deed to file this ejectment action, whether it is possible for PHH Mortgage Services to possess any genuine claim to ownership based on the sheriff's deed even if the deed were not void, and whether PHH Mortgage Services has any lawful basis whatsoever to initiate this or any other Idaho lawsuit without properly disclosing and establishing proof to act on behalf of PHH Mortgage Corporation. Further, PHH Mortgage Corporation did not appear as the real party in interest in this action, so they are barred from enforcing this ejectment action. Since PHH Mortgage Services was not granted the rights to our property in the underlying foreclosure action or the subsequent sheriff's deed, and they have fatally failed to demonstrate a link between the two entities to the court, they have approached the court without standing and foundation and cannot be lawfully heard as the real party in interest. The fraud, deception, legal chicanery, and fatal errors of PHH Mortgage Services appear to have no end. Therefore, since PHH Mortgage Services has still not claimed to be the owner of our loan, and as a matter of fact and record is not listed as the owner on the sheriff's deed, PHH Mortgage Services is not the lawful owner of our property, has no right to request our dispossession, have violated bedrock principles of due process, and their case in its entirety must be dismissed. Additionally, we requested a continuance to expand the factual record of the case and gather unanswered discovery which could have put this issue to rest. This critical dispute of whether PHH Mortgage Services is acting without lawful right in attempting to eject us from our property based on a sheriff's deed, whose veracity and authenticity is demonstrably tainted, is an essential element of this action and cannot be determined by decisions made more than over 5 and 7 years ago. Those decisions, if taken in error, must be reversed, and the erred laws of the case that guided them cannot be allowed to contaminate and fraudulently dictate the adjudication of the issues, disputes, and new evidence now before this court. Additionally, the sheriff's deed is invalid, inaccurate, and void on its face, so no ownership, interest, or right to possession was transferred or can be claimed by PHH Mortgage Services based on this defective title. The property was not struck off and sold to PHH Mortgage Services as the deed states. The authority to act was based on a void order of sale, writ of execution, and affidavit and application in support of issuance of writ of execution on judgment of foreclosure and order of sale on foreclosure. A credit bid was accepted from a non-lender in violation of law and order. The sale violated Idaho Code 11-304 as the property was 2 parcels. Other such defects and deficiencies exist which render the deed void and defective, and the sale or any subsequent ejectment action moot and unenforceable. Claim 3. The Nickerson family have the only clear title to 3165 Neff Road, also known as 139 Neff Road. We own our ranch by a warranty deed. It is prior in time, superior in right, and paramount to any deed allegedly placed on our property. Coldwell Banker Mortgage illegally filed a deed of trust on a 50-acre property in the Clearwater County land records. At no time did we agree to, grant, or knowingly sign a deed of trust in 2002. Coldwell Banker Mortgage assured us we were agreeing to place a mortgage against our property, we were getting a mortgage, and it was illegal to place a deed of trust on our property. PHH Mortgage Services admitted to this during the proceedings. We are still in possession of our warranty deed and our property, although our physical presence has been forcefully removed. Whereas Coldwell Banker Mortgage, Fannie Mae, JP Morgan Chase, and PHH Mortgage Services have no title that can be legally granted to them under an illegal deed of trust, they have corrupted their chain of title to an illegal instrument by their contradictory chain of title claims, and they do not have possession. We are the only lawful and legal owners of our property, and we request the state of Idaho exert itself to protect our property from deceptive acts and malicious harassment. JP Morgan Chase Bank and PHH Mortgage Services could not both own our property after the foreclosure sale. Not only does this create double indemnity liability potential and constitute an impossibility, but it is a mockery of the statutory auction process. We hold the only clear title to our property, and no lawful right to title can exist for PHH Mortgage Services or JP Morgan Chase Bank. Why contradictory claims regarding our chain of title matter? Reason number 1. A false chain of title cannot establish ownership or right to foreclose. One making contradictory statements is not to be heard. In the present case, the court ruled upon the motion for summary judgment without first resolving the factual issue of when the plaintiff took ownership and control of the note, and thus whether it had subject matter jurisdiction. In light of the documents before the court, showing discrepancies as to the date of the transfer of the note, as well as the defendant's argument that the plaintiff had not demonstrated that it was the holder of the note when this complaint was filed, the court improperly formed a legal conclusion without establishing the factual predicate for the court's subject matter jurisdiction. Accordingly, we reverse and remand the case to the trial court for a hearing to ascertain the plaintiff's status as the owner or holder of the subject note at the time the action was commenced, so that the court may properly determine whether it has subject matter jurisdiction. Contradictory statements and claims, as are detailed in sections 1 through 6 above, and our pleadings in their entirety, dispute and factually bar PHH Mortgage Services from claiming they are or have ever been the secured creditor of our note and mortgage by a clear chain of title. JP Morgan Chase Bank, PHH Mortgage Services, and those acting for and on their behalf have lied, fraudulently concealed critical information, committed fraud on the court, defiled due process, and corrupted the county records in their attempt to steal our property and wrongfully gain hundreds of thousands of dollars in undeserved equity. These illegal acts bar foreclosure and any post-foreclosure actions based on fraud, unclean hands, waiver, estoppel, and laches. An ejectment action requires title to be firmly established, and PHH Mortgage Services has fatally failed to present lawful title. Therefore, securing a summary judgment through false and contradictory claims, forged and void documents, and expired and void writs and judgments is unjust, immoral, illegal, and violates substantial rights outside of law and authority. Thus, a judgment based on false and fraudulent claims cannot be lawfully enforced. Idaho Code 6-101, Proceedings in Foreclosure Number 2, states the following. The provisions of this section must be construed in order to permit a secured creditor to realize upon collateral for a debt or other obligation agreed upon by the debtor and creditor. Chain of title is defined as successive conveyances or other forms of alienation affecting a particular parcel of land arranged consecutively from the government or original source of title down to the present holder. For the holder to have good title, every prior negotiation must have been proper. If a necessary endorsement is missing or forged, the chain of title is broken and no later transferee can become a holder. Holder is defined as someone who has legal possession of a negotiable instrument and is entitled to receive payments on it. A proper chain of title is essential to establish ownership and a right to demand payment. A broken chain of title excuses a debtor because the creditor cannot establish standing to claim injury without proof of right to title. A false chain of title is criminal, malicious, slanderous, injures the debtor, and invalidates any rights of the creditor because no right to action can arise from an illegal act. Further, PHH Mortgage Services has not presented a chain of title that is possible, plausible, or probable based on the evidence presented to the court and the rulings of the court. As demonstrated throughout this video in its entirety, PHH Mortgage Services is not and never has been a secured creditor based on a clear chain of title. Thus, PHH Mortgage Services does not have a right to act. Reason number 2. These false and contradictory claims fraudulently concealed truth to secure summary judgments which prevented a full and fair adjudication based on true merits. Colluding to fabricate false claims of chain of title to avert liability, avoid answering discovery, establish standing, and secure summary judgments is fraudulent and imposes severe, significant, and substantial injuries and damages on us. Allowing summary judgments to hide contradictory claims of ownership and rights to act by denying us due process or opportunity to be heard violates and abuses contractual agreements, state, federal, and common laws and regulations, and overreaches jurisdictional authority. Granting the right to foreclose with contradictory chain of title claims in the record is an abuse of discretion and constitutes an act of judicial tyranny. Reason number 3. Firm proof of ownership is required as conditions precedent to foreclosure or ejectment actions. Conditions precedent is defined. In a contract, an event which must take place before a party to a contract must perform or do their part. An act or event, other than a lapse of time, that must exist or occur before a duty to perform something promised arises. If the condition does not occur and is not excused, the promised performances need not be rendered. It is one which is to be performed before some right dependent thereon accrues, or some act dependent thereon is performed. Conditions precedent requires the authenticity and veracity of current ownership to be established by a clear and complete chain of title. If the correct identity of the lender cannot be established, a foreclosure cannot be initiated, much less relied on for an ejectment action. The right to foreclose is predicated by 3 elements. In an action for foreclosure, the foreclosing party must prove 3 things. Number 1, the debt of defendants. Number 2, non-payment of the debt. And number 3, present ownership of the debt by the complaining party. U.S. Bank was required to establish, through admissible evidence, that it held the note and mortgage, and so had standing to foreclose the mortgage before it would be entitled to summary judgment in its favor. Common law is the authority for an ejectment action in Idaho. An ejectment action admits the party in possession is a true and rightful owner. Further, since an ejectment action is a common law action, our rights as American citizens and guarantees under the Idaho Constitution have been and are being violated by denying our right to a jury trial. Trial by jury in civil cases. In suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved. 7th Amendment to the Constitution of the United States. Right to trial by jury. The right of trial by jury shall remain inviolate. Article 1, Section 7 of the Constitution of the State of Idaho. Forms of action abolished. The distinctions between actions at law and suits in equity, and the forms of all such actions and suits, are hereby prohibited. And there shall be in this state but one form of action for the enforcement or protection of private rights or the redress of private wrongs, which shall be denominated as civil action. And the fact at issue shall be tried by order of court before a jury. Article 5, Section 1 of the Constitution of the State of Idaho. Long-standing law, case interpretation, and common sense requires the person requesting ejectment to firmly prove ownership. Idaho courts have agreed. To establish the need for an ejectment action, PHH Mortgage Services must first prove true ownership and the right to eject. In an action for ejectment, the plaintiff must allege and prove, number 1, ownership, 2, possession by the defendants, and 3, refusal of the defendants to surrender possession. The essential allegations in an action for ejectment are that 1, the plaintiff has title to the land, 2, the plaintiff has been wrongfully dispossessed or ousted, and 3, the plaintiff has suffered damages. An action is not given to one who is not injured. The requirement for PHH Mortgage Services to prove ownership by a valid chain of title was unlawfully waived by the courts of Idaho. The chain of title narrative determined by the District Court and affirmed by the Idaho Supreme Court is incomplete and contradicts the chain of title claims presented by the parties, J.P. Morgan Chase Bank, PHH Mortgage Services, and Fannie Mae. Therefore, summary judgment granted foreclosure based on a fabricated, invalid, incomplete chain of title not based on the merits or truth. Judge Michael Griffin abused his discretion and did not have the authority or jurisdiction to just fabricate his own narrative that conflicted with the chains of title presented by all parties. The claim of title PHH Mortgage Services is now basing their action for ejectment on is based on a void, amended judgment, an expired writ of execution, an unlawfully conducted sheriff's sale, a grotesquely inadequate sales price, and an inaccurate and fraudulent certificate of sale and sheriff's deed. Judge Gregory Fitzmaurice has granted summary judgment on this ejectment action with evidence in the record that demonstrates PHH Mortgage Services committed fraud, fraud on the court, and fraudulent concealment to obtain any alleged rights in this action. PHH Mortgage Services does not have a valid title, nor have they established a right to challenge or steal our title from us. Reason number 4. Damages, injuries, and substantial loss of rights bar enforcement of any action without contradictory and disputed facts being proven. The courts of Idaho have granted PHH Mortgage Services the right to steal our property in error. PHH Mortgage Services has been granted this right, with PHH Mortgage Services virtually refusing to answer all discovery questions in the underlying foreclosure and this ejectment action, without ever considering our evidence, and with contradictory chain of title claims in the record. The damages we have suffered in our 10-year battle are nigh on incalculable. A homeowner experiences prejudice or harm when an entity with no interest in the debt forecloses. When a non-debt holder forecloses, a homeowner is harmed because he or she has lost her home to an entity with no legal right to take it. If not for the void assignment, the incorrect entity would not have pursued a wrongful foreclosure. Therefore, the void assignment is the cause in fact of the homeowner's injury, and all he or she is required to allege on the element of prejudice. As a result of PHH's breach of contract, by their direct and indirect actions and misconduct, the Nickersons have suffered and continue to suffer, and will continue to suffer reasonable, severe, and foreseeable actual, direct, predictable, consequential, and all-encompassing inconsequential damages. These damages, in addition to and in conjunction with all other damages contained in this complaint in its entirety, cannot be deemed fully comprehensive because the damages are ongoing and constantly expanding in scope and depth as concealed and suppressed discovery and the resulting consequences of it are found and uncovered. At a minimum, the Nickersons have suffered 1. Loss of enjoyment and benefits of their property. 2. Loss of their way of life. 3. Loss of their down payment, all principal, interest, and equity paid to date on the note and invested in this property. 4. Loss of ability to resolve disputed default due to prevention of performance, the direct and indirect actions of PHH and Chase, and the fraudulent misrepresentation of the true identity of the lender. 5. Loss of credit. 6. Loss of borrowing resources. 7. Loss of income. 8. Loss of business and investment opportunities, improvements, and expansion. 9. Extreme financial hardships. 10. Financial discrimination. 11. Higher interest rates. 12. Frozen appreciable and depreciable assets. 13. Extensive costs, expenses, resources, and otherwise productive time spent and incurred in fighting and preventing this fraudulent and wrongful foreclosure. 14. Damage to and resulting losses from the malicious attacks on and the intentional tarnishing of their personal, professional, and financial reputations. And 15. All other damages for breach of contract to be proven at trial. The full impact and severity of our injury and damages have culminated from years of abusive debt collection, intentional malicious foreclosure attempts and proceedings, and treasonous and perpetual assaults on our family and homeland. Judicial injustice and regulatory inaction has silenced and rendered laws in place to protect, preserve, and prevent our property from being taken from us without cause or right, our persons to be free from religious oppression, and our voice to be heard through due process, ineffective and without authority. We remain in possession of what is rightfully ours only because we have resolutely stood against broken laws, acute regulatory failure, and judicial error. We have fought amidst pain and suffering because we resolved those who stood and fought to give us these freedoms should not have sacrificed and died in vain. The damages and injuries inflicted on us have been severe, significant, and substantial, but their harm extends far beyond what has been suffered by our persons, property, and financial portfolio. The very core of our American citizenship, property rights, religious freedom, due process, have been attacked and denied constitutional rights and silenced by one unlawful demand after another in these proceedings. The sobriety and integrity of the county land records and security of law interpretation and enforcement, not only in this small community and rural state, but in the world at large, has been jeopardized and infected with bankster exploitation and mortgage terrorism. What has happened to us is not an isolated incident. It is an attack of epidemic proportions on our whole United States of America. Our family cannot help or protect everyone, but our hope is by protecting our one little piece of homeland, we can make a difference. All we have asked of the courts is to make those who have appeared with contradictory claims and forged documents to be required to prove they have a right to take what is rightfully ours from us. They have not. Thus, we have not, and cannot, and will not surrender possession of our property based on false claims or erred renderings that ignore and refuse to consider truth, facts, law, or evidence. Reason 5. It happened to us, and it can happen to America if an unbroken chain of title is not required to foreclose. Our Idaho ranch is being stolen by contradictory claims of chain of title, acute regulatory failure, systemic mortgage terrorism, and malicious foreclosure fraud. All access to account records, notations, tape recordings, or employees familiar with our accounts has been denied. No evidentiary hearings have been held. Evidence of crime and fraud presented to Idaho courts has been systematically and procedurally ignored and not considered. Contradictory and impeachable statements have been admitted and allowed to be edited at will to meet the ever-changing claims of ownership. Idaho courts have prejudicially ordered the theft of 17 years of time, resources, personal and financial investments without due process or a trier of fact having opportunity to address issues of fact. Fair play and justice require this matter be fully and fairly litigated to protect and preserve property rights for all. If our property can be taken from us, there is no property in Idaho that is safe or secure. These claims were never fully or fairly adjudicated. When we inherited this case, discovery was closed. No meaningful discovery had been gathered or entered in the record. Summary judgments had been granted. Our attorney had secretly withdrawn from the case months earlier, and everything we thought we knew about the case proved to be inaccurate. We requested a status hearing, but the bank turned it into a summary judgment hearing. None of our claims, evidence, testimony, or arguments have been considered. Our rights to due process have been denied. We have been prejudicially and procedurally prevented from presenting facts, evidence, laws, and authorities that dismiss all claims against us. We presented 26 affirmative defenses and 22 causes of action in our amended answer and counterclaim in the foreclosure case, but they were procedurally and prejudicially ignored and denied without explanation. Adjudication on the true merits of the case has never occurred. Truth 1. We are the rightful owners. We, the Nick and Donna Nickerson family, are the only true and rightful owners of our property. We hold and own the property by an actual deed which is in our possession. We have never, at any time, by action or inaction, given our consent for the property to be sold, lawfully encumbered to PHH Mortgage Services, or for any entity to be granted their lawful right to take possession of our property. Truth 2. No debt is owed. Money refused releases the debtor. We deny we owe or have ever owed PHH Mortgage Services any lawful debt or that we are in default of any mortgage or other debt allegedly placed on our property in 2002. Truth, facts, and evidence corroborate we more than exceeded all elements of substantial performance in making payments, providing exceptional maintenance to our property, and increasing the equity in our property value. All payments we were allowed to make were made. Any records that demonstrate otherwise are false and fraudulently created. PHH Mortgage Services has admitted they took over the servicing of our loan, refused to accept all further payments, and had no records of payments made or not made. No admissible evidence of default was ever provided to the court. The claims submitted were changed multiple times, demonstrating genuine issues of fact existed. Requests for further discovery to research and analyze any claims of default were reasonable and in accordance with laws and regulations, but they were denied. PHH Mortgage Services' actions and inactions caused any existing default, breached any alleged contract, released us from performance, and entitled us to the benefit of full performance. PHH Mortgage Services and their accomplices are guilty of fraud and serious violations of state and federal laws and regulations, among other such criminal actions. Truth 3. We did not default and dispute any claims otherwise. Default is defined as the omission or failure to perform a legal or contractual duty, especially the failure to pay a debt when due. The issue of default has never been adjudicated, as discovery has never been conducted in a fair and judicial manner, nor has any adjudication occurred based on the true merits of the case. PHH Mortgage Services and J.P. Morgan Chase Bank carry the fiduciary burden of record keeping and record retention. PHH Mortgage Services has admitted they never allowed us to make payments from February 2010 to present and that they had no previous account records. PHH Mortgage Services was not a party to any transaction that occurred or did not occur prior to February 2010. Therefore, all testimony presented by PHH Mortgage Services is not based on personal knowledge, nor has it qualified as admissible evidence. PHH Mortgage Services admitted. PHH is unaware of any payments made or not made by the Nickersons to Chase. Thus, our affidavit testimony regarding payments represents the only personal knowledge or admissible evidence presented to the court and is therefore the best evidence in the record. PHH Mortgage Services has admitted they refuse payments in their ordinary course of business. PHH does not keep a log of dates, amount of payments, and persons present when a payment may be refused. It is well established payment refused excuses the debtor and that PHH Mortgage Services is mandated to keep records of communications with debtors. They refused our payments and have denied us access to records. Censoring account records and notations to prevent criminal exposure does not align with fair debt collection procedures. Idaho courts prejudicially ignored and refused to consider our claims of no default. We made all payments we were allowed to make, knew to make, or instructed to make by J.P. Morgan Chase and to J.P. Morgan Chase. We were current and in good standing with J.P. Morgan Chase in January 2010 when PHH Mortgage Services began servicing our loan. Truth 4. Idaho courts erred. The District Court and the Supreme Court of Idaho have repetitively erred and failed to consider the truths of the matter in this case. A detailed review of the actual orders and rulings in this case demonstrate all judgments were rendered by summary judgment, affirmed by not considering truths and facts due to the file created by Judge Michael Griffin, and through procedural technicalities and legal chicanery. Every person who has looked at our evidence has determined PHH Mortgage Services committed fraud and criminal collusion in a targeted attack against our family. We have simply asked for Idaho courts to allow us our constitutional right to a jury trial and to require PHH Mortgage Services and J.P. Morgan Chase to provide records normally kept and required to be maintained in the normal course of business and opportunity for their employees familiar with our accounts to testify. Any reasonable person should question why the bank is so determined to conceal these records, notations, and phone recordings. Idaho courts have erred in refusing to require the truth to be produced. If Idaho courts are willing to allow our ranch to be taken from us, no home in Idaho is safe. An American family is being attacked for their faith on their homeland. We are fighting back because it is the right thing to do. If it happens to us, it could happen to you. Is this okay with you? Truth 5. This is a hate crime, malicious harassment, and a crime against humanity. Malicious harassment because of our faith signifies a hate crime and constitute crimes against humanity. Idaho courts refusing and failing to stop these crimes committed against our persons, property, financial portfolio, good name, and rights to enjoy our property free from threat or seizure creates extreme concerns regarding the Idaho judiciary's willingness and ability to protect property rights, religious freedoms, and due process in Idaho. The cruel reality is it was within Idaho court's power to have ended this attack years ago. Instead, we, our property, our family, and those we serve have been needlessly victimized and abused for years. All truth, facts, and evidence demonstrate PHH Mortgage Services did not own our property when they filed their complaint for foreclosure, that PHH Mortgage Services has no right to file or enforce any complaint against us or our property, and that PHH Mortgage Services is barred and prevented from claiming any injury caused by our actions or inactions. This entire foreclosure is rooted in fraud. All claims, judgments, and the proceedings in their entirety are slanderous and defamatory. These proceedings maliciously inflict severe, significant, and substantial damages on us and our family, property, equity, entire financial portfolio, good name, and the inalienable rights granted us in the United States Constitution. This is our home. We want to keep it. We have and have always had the wherewithal to keep it. We have fought and will continue to fight to keep it. So help us God.
This is Nick Nickerson.
And this is Donna Nickerson.
And we approve this message.